Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Can the Supreme Court decide a constitutional issue without actually deciding the constitutional issue? It's an interesting question, isn't it? How can you do something if you don't do something? Well, in spite of that, the answer appears to be yes. But before we get there, it's necessary to get a little history lesson here. After the Revolution, the Civil War, the Manifest Destiny period, and the rise of the automobile, the world was working reasonably well. When a constituent had a problem, they often could walk into the congressman's office in or near their home, and even if the congressman wasn't there, his staff was, and they could relay the concerns up to Washington. And of course, all of these congressmen came home during recesses and met with their constituents at the time, because it was considered to be a career in public service. And of course, congresspeople were held in great esteem, and they were all, for the most part, respected. So if you had an issue, you took it to your congressman, and sometimes congressional action would result. A lot of the laws made during that period of time were the direct result of someone coming up and saying, hey, this is a problem. A good example, although not a constitutional issue, a good example is speed limits. Once the automobile became pretty ubiquitous, well, you needed to have some way to regulate it. So that's the way the legislative system and the legislative branch tended to work between 1900 and 1920. Then in 1929, the Depression hit. And suddenly, being a congressperson was no longer the best job in town, because now all the people wanted something done, and they wanted something done about the Depression, and they were not happy about little things that were wrong in their life, like not being able to eat, not being able to afford medicine, not being able to afford clothes, that sort of thing. Apparently, it was really irritating. So I do have some rare footage from that point in time demonstrating what I think shows the abject compassion of those in government. I found it here on the YouTube archives. Let's take a look.
Your Majesty, I must have a word with you.
The Count of Money. Don't correct me. What is it?
Of course, Your Majesty. I've come on the most urgent of business. It is said that the people are revolting.
You said it. They stink on ice.
Oh, I guess maybe that wasn't Herbert Hoover, but at any rate, I think the approach that was being taken by Herbert Hoover, a Republican who was president at that time, was very similar to that. And he was perhaps the worst president of the 20th century. He's second only, the only person who's second to him would be, I think, Jimmy Carter. He was all doom and gloom, and when an optimistic socialist, Franklin Roosevelt, won the national election in a landslide, he brought with him a whole bunch of congresspeople who were more than willing to do his bidding to get the United States out of this financial morass that they were in. In doing so, he set up what is frequently described as the deep state. And what is the deep state? Well, specifically, it's a bunch of independent agencies whose directors were often appointed by the president for odd terms of years. So, for example, the FCC commissioners, their terms were staggered. And the guy who's appointed this year by President Biden, his term's not going to end until well after whoever is president next. So he gets to have some input into that agency for a longer period of time than previously. And they did that so that some of these New Deal laws that were being passed would make it easier to step up and take care of what the president and others saw as big problems. Now, as you probably remember, the Great Depression started with the stock market crash. And a lot of people who thought that the stock market crash was caused by people who overvalued stocks and sold them. The definition of a broker is often described as being somebody who invests your money until it's gone. And there were a lot of people who woke up on October 29th, 1929 and found out they didn't have any more money. So FDR got all of these laws through, and a lot of these laws were initially struck down, basically until FDR threatened SCOTUS and said, look, I'm going to pack the court if you don't stop this. Then all of a sudden, some narrow lanes in the Constitution started to open up for FDR to run through. The agencies were efficient in that the problems in their areas of concern, like the Securities and Exchange Commission, no longer required direct congressional action. The SEC could take action under its mandate, and Congress had turfed a lot of authority and a lot of discretion to these agencies. And while the majority of that time that discretion was well exercised, it was sometimes abused and still is. Now, two of the agencies created during this time, as I mentioned before, were the Securities and Exchange Commission, the SEC, and the National Labor Relations Board, the NLRB, because the 20s and 30s were really big times for labor unions and labor strife and that sort of thing. And actually, in this case, the one we're going to talk about, there are these two agencies are the two agencies who were involved. So with the history lesson concluded, and my apologies to the history guy, and by the way, if you haven't found the history guy on YouTube and you like history, you need to look him up because he's got a great channel. I'm subscribed, you should be too. One of the opinions that flew under the radar of the national media, as well as me at the time it was released last month, was Jarkisi versus the Securities and Exchange Commission. At first glance, it would appear to be a Seventh Amendment case. And I say at first glance for a reason. Hang with me. When Congress amended the SEC's charter with the Dodd-Frank bill, they changed the way enforcement was done by the SEC. Until Dodd-Frank, if the SEC wanted to impose fines or civil penalties, they had to go through an Article III court. So if XYZ Company in St. Louis got accused of manipulating their stop price or some other violation of the securities laws, under the old system, the SEC had to sue them in federal court if they wanted to impose fines or civil penalties. Not that there's a great deal of difference between the two. Under the amended statute, the SEC was given the option of going through the district court or through its own internal adjudication system. An adjudication system run by administrative law judges, ALJs, and where the final decision-making was done by the actual commission itself, by the members of the commission. So generally, this is how it works. And this would apply both to the SEC and the NLRB. A company commits a violation of the SEC rules. The SEC General Counsel investigates that claim. If the General Counsel finds reason to, he will file an enforcement action in either federal court or, as in this case, in the in-house adjudication system there in the SEC. So it goes up before an SEC ALJ, and the ALJ decides the case. He writes an interim order and sends it to the SEC commissioners for review. Then the SEC issues its final agency action. And once there is a final agency action, it can be appealed to the Circuit Court of Appeals. So, shortly after the passage of Dodd-Frank, the SEC began investigating Jarkisi and Patriot 28 for securities fraud. Between 2007 and 2010, Jarkisi launched 2 investment firms, raising about $24 million from 120 accredited investors. That's a class of investors that includes, for example, financial institutions, certain investment professionals, and high net worth individuals. Patriot 28, which was the firm that Jarkisi managed, served as the fund's investment advisor. According to the SEC, Jarkisi and Patriot 28 misled investors in at least 3 ways. 1, by misrepresenting the investment strategies that Jarkisi and Patriot 28 employed. 2, by lying about the identity of the fund's auditor and prime broker. And 3, by inflating the fund's claimed value so that Jarkizi and Patriot 28 could collect larger management fees. Color me shocked that somebody who invests money every day would cheat. Oh, the humanity. Relying on the new authority conferred by the Dodd-Frank Act, the SEC opted to adjudicate the matter itself rather than going into federal court. And in 2014, the presiding administrative law judge, or ALJ, issued an initial decision. The SEC reviewed that decision and then released its final order 6 years later in 2020. The final order levied a civil penalty of $300,000 against Jarkizi and Patriot 28 and directed them to cease and desist committing or causing violations of the anti-fraud provisions and ordered Patriot 28 to disgorge earnings and prohibited Jarkizi from participating in the securities industry and in offerings of penny stocks. As you might imagine, Jarkizi and Patriot 28 petitioned for judicial review. Ordinarily, that would be done in the district court if you were initially starting out in a lawsuit. But since there was already an adjudicating agency, in other words, the SEC, you were appealing from the findings of the SEC, so you went, instead of to the district court, you went to the Fifth Circuit in this particular case. A divided panel of the Fifth Circuit granted their petition and vacated the final order. Applying a two-part test from a prior case, Gran Financiera S.A. versus Nordberg, the panel held that the agency's decision to adjudicate the matter in-house violated Jarkizi's and Patriot 28's Seventh Amendment right to a jury trial. But they didn't stop there. Indeed, the Fifth Circuit held that the structure set up under Dodd-Frank for internal enforcement of civil penalties and fines implicated the president's powers under Article 2, and here was the way it worked. Jarkizi raised numerous constitutional defenses with the SEC in order to preserve them on appeal. The Commission rejected all of these constitutional arguments. Petitioners raised two that were important. In rejecting them, it determined that the removal restrictions on SEC ALJs did not violate Article 2 and separation of powers principles, and the other one is the proceedings did not violate the Seventh Amendment right to a jury trial. So the SEC's ALJ performs substantial executive functions, meaning they act as a decision maker and as a part of this administrative agency, which is an Article 2 agency. It's under the executive branch. So the president has to have sufficient control over the performance of these functions, and by implication, he must be able to choose who holds the positions. There were two layers of for-cause protection that impeded that control, and the Supreme Court precedent forbade such an impediment. Jarkizi's argument on this point was fairly straightforward. SEC ALJs are inferior officers. They can only be removed by the SEC commissioners if good cause is found by the Merit Systems Protection Board. SEC commissioners and MSPB members can only be removed by the president for cause. So SEC ALJs are insulated from the president by at least two layers of for-cause protection. So in order to get to the SEC ALJ, you would first have to remove the Merit Systems Personnel Board person who wouldn't allow you to remove them, and then you would have to remove the ALJ. And that much insulation is not provided for in the Constitution. So, as a result, that level of removal was governed by a case called the Free Enterprise Fund, which was a prior case that was decided by SCOTUS. The Fifth Circuit said, "We agree with petitioners and hold that the removal restrictions are unconstitutional. The Supreme Court decided in Lucia that SEC ALJs are inferior officers under the Appointments Clause because they have substantial authority within SEC enforcement actions. And in Free Enterprise Fund, it's explained that the president must have adequate control over officers and how they carry out their functions. If principal officers cannot intervene in their inferior officers' actions except in rare cases, the president lacks the control necessary to ensure that the laws are faithfully executed, which is the mandate of the executive branch under Article 2. So if SEC ALJs are inferior officers of an executive agency, as the Supreme Court in Lucia indicated was the case, at least for the purposes of the Appointments Clause, they are sufficiently important to executing the laws that the Constitution requires that the president be able to exercise authority over their functions. Well, that was what the Fifth Circuit decided, and as you might imagine, the SEC, with their hair on fire, petitioned SCOTUS to review the Fifth Circuit's decision. As you might imagine, the SEC, with their hair on fire, petitioned SCOTUS to review the Fifth Circuit's decision. They went to SCOTUS because, after all, the Fifth Circuit had just told them that a mechanism set up by Congress that had been in place since the 1930s was somehow constitutionally infirm. They took up 3 of the questions raised by Jarchese to SCOTUS in their petition. The Supreme Court only decided the Seventh Amendment issue, likely because they thought the law was fairly clear regarding the president's removal authority. Here's what SCOTUS said. We do not reach the remaining constitutional issues and affirm the ruling of the Fifth Circuit on the Seventh Amendment ground alone. Now, you could read that as saying, well, we're not getting to those issues because we don't need to, or you could read that as we're not getting to those issues because we believe they got it right. The Supreme Court did not say. Jarchese, then, is a Seventh Amendment case that decides only that question. Even though SCOTUS accepted all 3 questions for review, this is consistent with the High Court's process of issuing narrow decisions confined to the facts of the case. In other words, they decided on the most efficient grounds. Interestingly enough, because the Supreme Court accepted cert on all 3 questions, including the ALJ question, their refusal to offer what amounted to an unnecessary advisory opinion on the ALJ matter effectively established that the line of cases on dual layers of removal control are still valid and reflect current precedent. Enter Elon Musk. Now, Elon, I saw a video of him discussing how he hires people, and one of the things he does is he only hires smart people, and then he tests them with questions about problems they've solved and how they solve them. And he says that's because people who've solved problems know exactly how they solve them. And if you can do that, then that's how you get to work for Elon. Elon hires lawyers apparently the very same way. So several years back, Elon fired 8 workers from SpaceX, and they were immediately greeted with an action by the National Labor Relations Board. Now, the workers complained that they were fired for complaining about a lack of diversity and that this violated the NLRB's Protective Concerted Action Doctrine. And that's a doctrine that essentially says you don't have to have a union. You can do this without a union. If you all get together and go complain about your wages, that's protected, concerted activity, and you can't be fired for that. So the NLRB did a fact-finding, and they got ready to queue up an administrative hearing in front of an administrative law judge. Not so fast there, NLRB. Elon's lawyers had read both the Jarchese opinion from SCOTUS as well as the Fifth Circuit opinion. The Fifth Circuit, the controlling circuit for Texas, where SpaceX is and where Elon sought an injunction in district court, had held that the multiple levels of removal prevention was an unconstitutional structural problem in Jarchese. Now, SCOTUS never overruled this holding in Jarchese, so it was still valid authority in the Fifth Circuit. So Elon's lawyers sought to enjoin any enforcement of the complaint issued by the NLRB. Now, SpaceX alleges that in similar fashion to the SEC ALJs, the NLRB ALJs are unconstitutionally protected inferior officers who perform substantial executive functions. Defendants do not attempt to distinguish the SEC ALJs from the NLRB ALJs. Geez, this is like reading the ABCs backwards through a prism. Both are inferior officers who have substantial authority in agency investigations and enforcement actions. The SEC and NLRB ALJs are only to be removed when the MSPB, the Merit Systems Personnel Board, finds good cause. Further, the MSPB members may only be removed by the President for inefficiency, neglect of duty, or malfeasance in office. The court found that under current Fifth Circuit law, there is a substantial likelihood that SpaceX succeeds on the merits with regards to showing that the NLRB ALJs are unconstitutionally protected from removal. Now, it did this by noting that while the Supreme Court granted cert on 3 issues raised by Jarkizi, it never reached issues 2 or 3 as it resolved the case on the 7th Amendment only. The issue before the court today is issue 3. For a Supreme Court decision to change Fifth Circuit's law, it must be more than merely illuminating with respect to the case before the court, and must unequivocally overrule prior precedent. SCOTUS did not voice disagreement, much less overrule the Fifth Circuit's holdings with regard to issue 3, and it directed it to Jarkizi. Accordingly, this court remains bound by Fifth Circuit precedent in this case. Now, the NLRB is going to appeal, and it will go to the Fifth Circuit, which will likely affirm. The NLRB will have to take it to SCOTUS to get a remedy if one exists. Keep in mind that while the SEC issue was a new one brought about by a change in the law, the NLRB has been in existence since the 1930s, and the enforcement mechanism has been largely the same that whole time. Now, the court enjoined the NLRB. They issued an injunction as followed. It is further ordered that the National Labor Relations Board, and then he lists the officers of the NLRB, and all of their officers, agents, employees, attorneys, janitors, and other persons in active concert with them, hereinafter defendants, are enjoined from administratively proceeding against plaintiff SpaceX Exploration Technologies Corp. In the matter associated with NLRB case number 19-CA-309274. While that's a narrow ruling, and it's an injunction that establishes a preliminary injunction, and then they'll decide the issue on the merits later on, the logic of the opinion is pretty good. And anyone else facing an NLRB action in the Fifth Circuit is now going to be well advised to do exactly the same thing, seek an injunction on the same grounds. I think this is a really interesting development, and it's one that I'm going to keep my eye on. Anytime anything changes the way our system of government works, and this is a structural change in how our government works, we need to pay attention. We need to watch what's happening. We need to understand it. Because if we don't understand what's happening, we're liable to reach wrong conclusions for all the wrong reasons. If you have any questions, drop them in the comments down below, or you can email me at the address above. And if you can do a kindness today, please do so. It makes the world a better place. That said, come on back tomorrow. Join me down here at the beach, and we'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.